Justice, Associate Justices, and may it please the Court. My name is Ash Dadwani, and I represent the respondent on the merits of their Fourth Amendment issue, whereas my co-counsel, Gabriella Epley, will represent the respondent on the merits of their Sixth Amendment issue. There are two key points that this Court should focus on today. One, that the warrantless seizure of evidence obtained on January 16th is not a violation of the petitioner, Mr. Bronner's Fourth Amendment rights. And two, that obtaining a burner phone does not demonstrate an expectation of privacy that this Court should recognize as reasonable. For January 16th warrantless seizure of evidence, the petitioner's counsels argued that it was a violation of this Court's decision of Carpenter v. United States because it cataloged every movement of an individual. However, that is not the kind of catalog that this Court, that is not the kind of cataloging every movement what it looks like as it has been established in Carpenter. When the government catalogs every movement, we see that there were 13,000 pings, that the government was able to tell exactly when Mr. Carpenter moved from point A to point B. But on January 16th, a mere notification of when an individual is within 5 miles of these 10 specific locations does not mean that they were cataloging the petitioner's movements. Furthermore, the data that was collected was in real time and not retrospective. In Carpenter, there's a reason why this Court did not rule on real-time data and said that the retrospective data is a violation of an individual's expectation of privacy because the government can't go back in time and stake out an individual on that day. So they merely have to rely on the cell phone records and they can track an individual's movements. Here, it was just a notification, and it is similar to the case that this Court has already ruled on, such as Knott's v. United States. In Knott's, when a GPS tracker was covered in chloroform, this Court ruled that it was allowed because the information it revealed was limited and it was exposed for anyone to see in general public space. Here in Mr. Bronner's case, he was in general public space and his movements were exposed to anyone to see, which is why it is not a violation of Carpenter v. United States, and this Court should not accept petitioner's arguments. As for the second warrantless seizure of evidence that occurred on February 3rd, which is the same argument that has been given for February 7th as well, the petitioner argued that because Mr. Bronner had obtained a burner phone, he exhibited an expectation of privacy. If this Court today buys the petitioner's argument, they will have to rule on the devices that maintain an individual's expectation of privacy. For example, if an individual has burner phones and the numbers that they dial, they have an expectation of privacy in those numbers. However, if that same person uses a home telephone, they do not have an expectation of privacy in the numbers that they dial. We see that consistently, this Court has never ruled on the devices of what an individual uses, but what those devices or what the information was revealed and how it was used against an individual. For example, in Smith v. Maryland, it was the numbers that were dialed, not that the fact that it was a home phone. In United States v. Jones, it was what the device was used for, such as it tracked the vehicle for 28 days, not the fact that it was just a GPS tracker.
Counsel, what's the important data here being collected by the police? The location by pings or the phone numbers being dialed?
Your Honor, the information both of these information are important. It helped the task force reveal the people that were connected to the human trafficking and the 10 specific locations that were important in the task force investigation. When we look at Warrant 6, we see that these 10 specific locations are also important on Warrant 6 as well. That was obtained on January 25th after January 16th. These locations were important in the human trafficking investigation. But however, for February 3rd and February 7th, just because an individual obtained a burner phone does not mean that they now have more expectation of privacy than the person who used their home phone. Furthermore, the petitioner argued that there is not enough evidence in our records to indicate why Mr. Bronner might have obtained a burner phone. But when we see why on February 2nd, when the CI was asked about the burner's phone that Mr. Bronner had obtained, the CI informed the task force that Mr. Bronner had said that Danoff is changing phones every week in case the police is tracking him. So when Mr. Danoff changed phones, so did Mr. Bronner. who was associated with Mr. Danoff as well. There is enough evidence to indicate why Mr. Bronner felt the need to change his phone and to obtain a burner phone when he was okay with using his cell phone up until February 3rd.
Why didn't the government get a warrant for the second warrantless search? Why didn't they just get a warrant?
Your Honor, there was no need to get a warrant.
Well, then why did they get a warrant for 2 or 3 times after that?
Your Honor, just because a task force was able to get a warrant, there's a difference between when they willingly want to get a warrant, even when they don't need to, versus when they do not because they're not required to do so. It is true that the task force may have gotten a warrant for the future when to reveal the numbers that Mr. Bronner had communicated with. But the question is, did they need to? Did they violate Mr. Bronner's Fourth Amendment rights?
With respect to the second warrantless search, were the police faced with the possible destruction of evidence? And if so, what?
No, Your Honor. We are not arguing that there was a possible destruction of evidence. Our Appendix 1 shows us that the records of cell phone companies are held up to a year, and the task force did have access to those records for a whole year. There was no destruction of evidence needed. It was that Smith v. Maryland did not require the task force.
For what
to
reasons
get those.
it was my understanding that the police officers, the investigators, when they went to the cell phone provider, again for the second warrantless search, that they said something to the effect of, we're concerned about destruction of evidence. There's time is of the essence. In other words, they gave the impression that there was an emergency sort of situation here. You're telling me now there's not? That they mislead them?
Respectfully, Your Honor, in the lower court's decision, the court did rule that there was a destruction of evidence. But when we see what the 2 task force officers had said, they consulted themselves and said the time was of the essence, which it was. It's January 16th. The Super Bowl is on February 7th, and they still needed to get evidence and investigate Bronner and any of the associates that might have been involved in human trafficking. But it did not mean that they thought that evidence was going to be destroyed. Furthermore, when we look at what they had told the Olympus Cellular, it was that the health of the community was at risk, which it is, because human trafficking was going to impact every single member of the community.
But isn't that all undercut by the fact that subsequent to that, they took the time to get a couple more warrants? If your argument's accepted, they shouldn't have taken the time to get warrant 6 and warrant 7, right?
Again, Your Honor, respectfully, even though they did get the warrants, for the warrantless seizures of evidence that are in question, they did not need to get that warrant. So if the question is whether Mr. Bronner's Fourth Amendments were violated, they were not, because this court does not require the task force to get these warrants under these circumstances.
Even though they gave, the investigators on the second search, gave Olympus false information, told them that there were exigent circumstances when in fact you're telling me there wasn't. So they got them under false pretenses. Is that what you're saying?
Your Honor, the information that the 2 officers had given was on January 16th, and that was when, rather than on the second warrantless seizure of evidence, and explaining that the community was at risk was not a false pretense. Even on February 7th, when we see that they were rendering aid and emergency to these community members, it is not a lie. There were potential victims that were going to be trafficked, and they were subject to trafficking. The petitioner might come up here and argue that there was no emergency rendered to a specific victim. However, arresting 50 associates and Mr. Bronner indicates that emergency was given. Removing the threat of human trafficking from a community shows that there was rendering emergency aid to those victims. Approximately 600,000 to 800,000 humans are trafficked annually. So to prevent adding more to that number, it was important for the task force to render that emergency aid. They did not need to physically find a victim that was going to be affected by it, but they needed to remove that threat, which Bronner and his associates were. For these reasons, since Carpenter of the United States was not violated on January 16th, that for obtaining a burner phone is not an expectation of privacy that this court should recognize reasonable, because it creates multiple different standards of expectation of privacy. We ask this court to affirm and uphold the decision of the Supreme Court of Olympus. Thank you.